Here's a quick update on a Massachusetts foreclosure case that impacts estate planning and many other professionals, because it limits who can challenge a foreclosure under the Pinti case. I'll often get asked, what happens to my mortgage if I die? And I explain that while death is not an event of default, the people who continue to reside in your property may not have the rights under the mortgage that you do. For instance, they may not be able to talk to the mortgage company, and they may not receive notices unless they open probate and step into your shoes. And a recent case makes this possibility even more likely. But first, let's take a quick refresher on what Pinti is. The Massachusetts Supreme Judicial Court held in a case called Pinti that lenders must strictly comply with paragraph 22 of the standard form mortgage before they can foreclose. That paragraph requires notices of default that clearly tell the borrower that they have the right to cure, the right to reinstate the mortgage, and the right to bring a court action to challenge the foreclosure. If that notice is defective, the foreclosure is void, not just voidable. In this case, NTGLQ investors foreclosed on a property after sending a paragraph 22 notice to the borrower. The borrower had transferred the property to his ex-wife years earlier after they were parties to a divorce, but he remained as the only person on the mortgage. After foreclosure, the ex-wife stayed at the property and raised a Pinti defense, arguing that the notice of default was defective. The appeals court said that she didn't have standing. You might ask why, and the reason is because Pinti rights belong to the mortgagor, the person that signed the mortgage. She was not a party to the mortgage, she wasn't an intended beneficiary of the mortgage, and she didn't even have an obligation under the note to make payments. And even though a defect can void a foreclosure, you still have to show that you have the legal right under the mortgage to raise the claim. So if you're a professional in Massachusetts that helps clients with finances, real estate, any other thing that might impact their home, what you need to keep in mind is that the protections only belong to the borrower on the mortgage. Even though a defective notice can void a foreclosure, only someone with legal rights under the mortgage can raise the issue. This is especially true given the number of mortgages with less than 3% interest rates. Divorcing couples may not be able to afford to refinance, which leaves the owner open to these issues. And this is particularly worrisome for self-represented parties who might not see this coming. Owning the property is not the same as having mortgage rights. Clients may receive property through divorce, inheritance, by virtue of planning, but if they're not on the loan, they may not have standing to challenge a foreclosure. Not every occupant can unwind a foreclosure sale. This decision limits who can raise Pinti defenses and reduces the risk for buyers, investors, and lenders who are relying on completed foreclosures. So the bottom line is this: when you're advising clients, you should always ask who's on the mortgage, who has contractual rights, and don't assume ownership or occupancy means that they're entitled to notice or any other rights under the mortgage.